you steal a loaf of bread in Cape Town today, are you being judged by a law written in 2024, a 17th century Dutch custom, or the Constitution? The answer is, all three. And here's the part that breaks first-year students every single time: knowing which one takes priority. This is the difference between a 55% and a distinction in CRW1501. By the end of this video, you'll know exactly how to use each source in an exam answer. Let's go. Most students think the law is just a giant book sitting on a dusty shelf in Pretoria. It's not. South African criminal law draws from 4 completely different sources, and they are not equal. They have a hierarchy, a pecking order. Get that order wrong in your exam, and your whole answer collapses. Today, we're building the 4 pillars of South African criminal law. This is the foundation of your module. Everything else, culpability, unlawfulness, sequence of liability, sits on top of this. So if the foundation cracks, everything above it cracks with it. Stay with me. This is about to get interesting. Oh, and before we get to source 3, I'm going to tell you the one Latin phrase that has appeared in UNISA exam papers more than almost any other. You're going to want to write it down. Source 1. The Constitution of the Republic of South Africa, 1996. Let's set the scene. South Africa, 1994. Apartheid ends. A country that had used its own law, its own courts, its own statutes, to systematically oppress millions of people, now has to rebuild an entire legal system from scratch. And the architects of that new system made one decision that changed everything. No law, not a single one, sits above the Constitution. Think of it as the parent of every other law. Parliament passes an act, the Constitution can override it. A court makes a ruling. If it violates the Bill of Rights, that ruling is invalid. A 200-year-old common law rule? Gone, if it contradicts Chapter 2. The Constitution doesn't just sit at the top of the hierarchy. It tells every other source of law what it's allowed to do, and, crucially, what it is not allowed to do. Now here's your first exam concept hiding inside this source. The principle of legality. Write this down. Nullum crimen sine lege. Nulla pena sine lege. No crime without law. No punishment without law. This is the principle that says the state cannot arrest you for doing something that wasn't a crime at the time you did it. It sounds obvious, right? But think about what it actually means in practice. It means the government cannot invent a crime after the fact and apply it backwards to your conduct. It cannot punish you with a sentence that didn't exist in law when you acted. It cannot convict you based on a vague, undefined offense that no reasonable person could have understood. This principle is anchored in the Constitution. When UNISA asks you to explain the principle of legality in an exam, they want you to tie it back here. Not to a statute, not to a judge's opinion, to the supreme law of the Republic. Now, quick question. If the Constitution is supreme and protects your rights so thoroughly, why do we even need Parliament to write laws at all? Why not just let the Constitution handle everything? Because the Constitution is broad. It's a framework. It says, you have the right to dignity. You have the right to freedom and security of person. But it doesn't tell you specifically what happens to someone who breaks into your house at 2 a.m. That's where Source 2 comes in. Statutory law. This is Parliament doing its job. These are the laws actually written down, debated, voted on, signed, and published in the Government Gazette. The Roman Dutch lawyers who laid the foundation of our common law, brilliant as they were, did not anticipate the internet. They did not anticipate synthetic drugs that didn't exist in 2005. They didn't anticipate identity theft happening in 0.3 seconds across a fiber line. Common law evolves slowly. Parliament can move fast, so when a new form of harm emerges, Parliament passes an act. The Cybercrimes Act, the Sexual Offences Act, the Child Justice Act, the Prevention of Organized Crime Act. These statutes fill the gaps that common law cannot fill, and they update definitions that common law got wrong, or simply never addressed. This is what lecturers mean when they call it black letter law. It is precise, it is written, it has a section number and a commencement date. If the crime you're studying has a statute attached to it, that statute governs. You don't go hunting for old Dutch legal texts. You go to the act. Here's the exam trap students fall into with statutory law. They assume that because something is written in an act, it automatically survives a constitutional challenge. It does not. Parliament can pass a law today that the Constitutional Court strikes down tomorrow. The Constitution always wins. Which brings us to the source that confuses almost every student the first time they encounter it. Source 3. Common law. Here's where students usually trip over their own feet. South Africa uses a hybrid legal system. We are neither purely common law like England, nor purely civil law like France. We are Roman Dutch, run through centuries of adaptation, colonial history, and court decisions. And the result is a body of unwritten legal principle that sits at the very core of how we define crime in this country. When I say unwritten, I don't mean undocumented. I mean it was never consolidated into a single act. There is no Murder Act, 1652. There is no theft statute. These crimes, murder, theft, rape, robbery, assault, are common law crimes. Their definitions come from legal scholars like Johannes Vogt and Hugo Grotius, who wrote in the 1600s and 1700s. Their work, refined by South African courts over centuries, is where we find the essential elements of our most serious offenses. Think about what that means. If you are charged with murder, the starting point for defining that crime traces back to a Dutch legal writer who was born in 1647. That's not a glitch in the system. That's the system working exactly as designed. We kept what was logical, discarded what was unjust, and built on top of it. And here's the twist students always miss. Common law is not static. Judges can develop it, courts can refine it. The Constitutional Court has directly modified common law rules that violated the Bill of Rights. So it's ancient, yes, but it's alive. If you want to understand South African criminal law at a deep level, you have to make peace with the fact that some of its most important rules were never voted on by Parliament. They were reasoned into existence by scholars who wrote in Latin. Speaking of Latin, here's that phrase I promised you. Actus non facit reum nisi mens sit re. An act does not make a person guilty unless the mind is also guilty. This is the principle of culpability, and it lives in common law. It is the reason you cannot be convicted of murder if you accidentally kill someone with no intention or negligence. The act alone is not enough. The law requires something from you, from your mind. We'll break this down fully in the next lesson on the sequence of liability. But plant that phrase in your brain right now. It will come back. Source 4. Case law, judicial precedent, the final pillar, and arguably the one that does the most practical work. Picture this. Parliament passes an act. The act says something, but what does it mean? What counts as unlawful? What qualifies as intention? What happens when two constitutional rights collide in a criminal case? Parliament wrote the words. Someone has to interpret them. That someone is the judiciary. Case law, also called judicial precedent, is the collection of court decisions that tell us what the law actually means in practice. And in South Africa, we follow the doctrine of stare decisis. Stand by the decision. Here's what that means concretely. If the Supreme Court of Appeal rules on a particular legal question, every high court below it is bound by that ruling. Not guided, not advised, bound. They must follow it. If they don't, their decision will be overturned on appeal. Now, the Constitutional Court sits above the Supreme Court of Appeal on constitutional matters. Its decisions bind every court in the country, including the SCA. One judgment from the Constitutional Court can change how a legal principle is applied from Cape Town to Polokwane overnight. You've already encountered the most famous example. Makwanyane, 1995. The Constitutional Court ruled that capital punishment was unconstitutional. One case, one judgment, and the death penalty in South Africa was over. Not an act of parliament, not a constitutional amendment, a court decision, using case law as its instrument. That is the power of judicial precedent. It is not soft, it is not optional, it is the law, and there you have it. The four pillars: Constitution, statute, common law, and case law. CSCC. Burn that into your memory before your next assignment. But here's the thing I need you to understand before you close this tab. These four sources don't operate in isolation. They talk to each other. A court interprets a statute in light of the Constitution. A common law rule gets modified by a constitutional court judgment. Parliament passes a statute to replace a common law rule the courts found inadequate. The whole system is in constant conversation, and the exam questions that separate distinction students from the rest are the ones that ask you to show that conversation, not just recite the pillars one by one. In the next lesson, we're going deep on the sequence of liability, the 4-step checklist every court uses to determine whether a crime has actually been committed. If this video saved your marks,